live.
Good afternoon. Welcome to Seat at the Sitting for October 2025. I'm Nate Kazmarek, Vice President for Practice Groups and Networks. Playoff baseball is here. The cooler fall weather has arrived, and we are once more looking forward to the Supreme Court reconvening for oral arguments next week. As you've come to expect, we've gathered an excellent panel to preview this month's oral arguments before the court. Our plan is to cover the cases and to take audience Q&A in 90 minutes or less. The usual disclaimer applies. The Federal Society doesn't take any positions, and all views expressed here belong to our speakers. I'm delighted to welcome a great moderator today in Ariel Azarad. Thank you for joining us, Ariel. How are you today?
I'm doing wonderful. Thank you for having me.
Well, we're delighted to have you. We're glad you could carve out time to guide our conversation this afternoon. Ariel is litigation counsel at the National Jewish Advocacy Center, which combats anti-Semitism, and is of counsel with Holtzman Vogel and focuses her practice there on commercial litigation, appellate law, and constitutional law matters. She clerked for Judge Stephen Menashe on the U.S. Court of Appeals for the Second Circuit. She is also a co-founder of the Center for Middle East and International Law with the Antonin Scalia Law School. Full bios for our moderator and all of our panelists are available for your review on our website. Also, we've added a feature to the Zoom platform. If you click the resources button, you can review each of our panelists' bios there. Towards the end of the program today, we'll go to audience Q&A. So please start thinking about the very difficult questions you'd like to stump our experts on as you listen to the panel discussion. For those of you joining us via Zoom, questions can be submitted in advance via the Q&A function at the bottom of your screen. With that, the table is set. Ariel, thanks again for being with us. The floor is yours.
Thanks for having me. So I'm going to do just a brief bio as the cases are presented. So we're going to start with Jana Bosch. She is the Deputy Solicitor General of Ohio. And before joining that office, Jana clerked for Judge John B. Nalbandian of the United States Court of Appeals for the Sixth Circuit and for Judge Allison Jones Rushing of the United States Court of Appeals for the Fourth Circuit. So without further ado, Jana Bosch is going to discuss Villarreal v. Texas, and I'll give her the floor. Thank you, Jana.
Thanks. So Villarreal versus Texas is getting argued in just 3 days. So we don't have very long before we get to watch the advocates advocate for themselves. In the meantime, this is a Sixth Amendment case, so right to counsel for defendants at trial. And to sort of set the stage for this, you have, under the Sixth Amendment, you have a right to consult with your counsel, at least as it's interpreted right now. And there's two sort of rough guideposts that the Supreme Court has already in this area. One is this case called Gators, not really sure. And it dealt with an overnight complete bar on discussion between the defendant and his counsel because they were in the middle of the defendant's testimony. And so the court said, in order to deal with the potential for some sort of taint in the testimony, we're just going to have a complete bar on the defense talking with this counsel for the entire overnight recess until we come back. And the Supreme Court said you can't do that. They said that that definitely crossed the line to violating the right of counsel for the defendant, because mainly its main point was that there are all kinds of things that defendants would want to discuss with their counsel during that overnight recess, many of which don't really have much to do with the ongoing testimony. And so to prevent them from talking at all prevented them from talking about a lot of different strategy issues, practical concerns for how the trial would be run, and that's a problem. The other guidepost goes the other way, and it's a case called Perry. And in that case, there was a 15-minute recess during the testimony, and the court, again, had a complete bar on discussions between defendant and his counsel, and the Supreme Court said that was okay. And one of its comments in saying that was okay was that there's really not a lot that you would expect someone to discuss with their counsel during a 15-minute recess other than their ongoing testimony. And so on that assumption, it says, There's really nothing wrong with preventing a defendant from discussing his testimony with his counsel or that 15-minute break. So that brings us to the Villarreal case, where the court called a overnight recess, and it again had a ban on a qualified ban this time on discussions between defense and his counsel. And the qualified ban was something along the lines of, don't discuss the ongoing testimony, but you can talk about anything else. And at the time, the counsel more or less basically said they understood the instruction and were willing to go along with it. When challenged on appeal, the Texas courts approved that qualified conferral ban. They said that's okay because we're looking at the truth-seeking function of the court. We're looking at the ability to have this qualified limitation, not a total limitation, even in the context of an overnight recess. And so they approved that. So then the question is the Supreme Court going to approve the sort of qualified conferral ban in the vein of Perry, where you're looking at trying to limit essentially taint of the defendant's testimony, or would they see this as being closer to Geter's just because essentially it has that overnight aspect to it? Villarreal argues that the overnight ban on, even though it's qualified to talking about testimony, and that's the only part that they're not allowed to talk about, that really isn't a distinction that makes any difference, because so many different pieces of what the defense would want to talk about with his counsel is going to be related to the testimony somehow or another, whether it's about something that he said makes the defense counsel want to call a certain other witness or do other certain research, that those relationships between what the defendant has been talking about on the stand and those strategy calls that they want to discuss during the overnight recess, it's going to be impossible to sort of extricate the testimony discussion from the strategy discussion. And even if you could, in theory, pull those two apart, the fact that you have the specter of punishment for discussing the wrong things means that you're going to essentially chill counsel's discussion with his clients. And so even things that if you looked at it technically would be allowed, he still might not discuss those things because he'd be concerned about that potential for punishment. And so the conclusion there is that a qualified ban like this is tantamount to banning consultation altogether. That you really can't say just because it's qualified means that it's allowed. He also points to some potential practical concerns in enforcing a ban like this, because how would you know what someone had talked about with their counsel unless you ask them what they talked about with their counsel, which has obvious problems there for confidentiality. Texas comes back and says that qualified conferral orders are constitutional, that they're actually fine in light of the precedent we discussed. And they pointed to the spots in Geter's and Perry where really the driving difference wasn't necessarily the length of the time of the recess. The difference was what the court assumed they would be talking about. In Geter's, they assumed that everyone would be discussing, would have these strategy matters to discuss, and they wouldn't necessarily be talking about testimony. And in Perry, they assumed that they wouldn't be talking about strategy, and the only thing they would be discussing would be testimony. So if you really take the heart of those cases and you apply it here, the qualified limitation on discussion is actually exactly what that sort of reading between the lines in Geter's and Perry would point to. They use this term testimonial management to describe what it is you don't want counsel to be doing, which is essentially telling their client how they should be answering questions on the stand. It really undermines the truth-finding function of the courts. And they also give a nod to the original meaning of the Sixth Amendment and discussing how that really has expanded over time. And originally speaking, this isn't something that would be considered to fall under Sixth Amendment protection. Ohio filed an amicus brief along with some other states, really highlighting how states have different methods that they come up with, some of them similar, some different, to protect that truth-seeking function in courts, which is essentially the core function of the courts, is to figure out what the truth is. And so the courts all the time will limit the timing of conferral with counsel. So it's not actually unheard of for defendants to request a immediate pause in the testimony when they get a question that they don't know how to answer and ask to talk to their attorney about how to answer it. And that's clearly a problem for maintaining the integrity of the trial. And so state courts frequently don't allow that. In a similar vein, courts have limited the topic of conferral between the counsel and the client. For example, like this one saying you can't discuss the testimony, but also limitations like not being able to discuss classified information that only counsel knows about. They can't tell their client. There's another case that came out of a federal court about not sharing information about a witness that was going to appear the next day out of safety concerns for the witness who had been the victim of some intimidation. And so when you look at the ability of state courts to put these reasonable limits on discussions between counsel and their clients, all of this goes to that truth-seeking function of the courts. If you do have this overriding, overwhelming Sixth Amendment right to confer essentially without limits, then that's going to make those sorts of truth-seeking protections impossible. And finally, we made a note in that brief that this really does benefit everyone, because if courts have to use scheduling of trials to avoid the kinds of recesses that will permit some witness coaching, then they probably will do that, and it will lead to some long nights of testimony when everybody would have been better off with a qualified conferral prohibition and picking it up the next morning. And the last thing I'll talk about is the U.S. Also put in an amicus brief. They made some points about how the defendant is in a special position as to the trial as a defendant, but they're not in a special position necessarily when they come as a witness. And so the kinds of rules that apply to witnesses in order to protect those truth-seeking functions we've talked about are by and large going to apply to defendants in a very similar way as the other witnesses, for the exact reason that they are truth-preserving rules. The U.S. also pointed out some historic limits on the right to testify and the right to confer, pointed out, again, like I mentioned, how much the Sixth Amendment right has expanded. And so to the extent that we're looking back at that original meaning to decide how much further to expand it, that would really point against continuing to expand that. And finally, they point out that at least so far, the Supreme Court has pretty much assumed that a qualified conferral ban would be workable, because in Perry and footnote 8, it actually suggests that as a resolution for those smaller, the 15-minute recesses. And so there's not really any reason to think that the Supreme Court would not accept that as a solution for also those longer recesses of putting just a qualified ban on talking about the ongoing testimony. So that sort of gives you a sketch of what's happening. The big question on everybody's mind is, would the Supreme Court be inclined to overrule Geters, or would it be more inclined to sort of take those two guideposts and explain why this one sort of falls in the middle, in a way similar to what the litigants have done, sort of trying to just take those two as a given and then cut a middle path and say, well, this favors one side or the other. So that's it. I'm not sure if it's just me, if I can't hear you, or if you're muted.
I apologize. Thank you, Jana. I'm sorry.
Sorry.
I was just prompting the audience for questions. If they had any questions about your presentation, they can put them in the Q&A box. I'm happy to review them, and people can fire away. And if not, I will move on to the next presentation. Thank you, Jana, for that. Our next presenter is Michael Morley. He is the assistant professor. He's an assistant professor at Florida State University College of Law, where he teaches Fed courts, remedies, and election law. Prior to his experience in academia, he served in government as special assistant to the General Counsel of the Army at the Pentagon, as well as a law clerk for Judge Gerald Tischoflat of the U.S. Court of Appeals for the 11th Circuit. So Professor Morley is going to first be discussing Berk v. Choy. So without further ado, Professor Morley.
Great. Thank you very much. So this case might be something of a blast to the past for most of you, in that it's an eerie case. So hopefully pleasant memories of civil procedure are coming back into your heads here. So in this case, the plaintiff, Harold Berk, had fallen out of bed and had injured his ankle and foot. He was taken to a medical center where the defendant, Dr. Wilson Choy, among other things, suggested that he wear a special type of boot in order to alleviate the injuries.
And the plaintiff alleged that the staff had a lot of trouble putting the boot on the plaintiff and were trying to shove it on and weren't able to get it on right, and allegedly made his condition much worse. He was subsequently transferred to another facility that didn't x-ray him. And ultimately, it wasn't until later that when he was x-rayed, they discovered that he had 3 different bones in his ankle that were pointing in 3 different directions, and he required surgery. It took him several months to recover from the surgery, additional months of therapy to be able to walk again. He requires a cane to walk. And so the plaintiff, Mr. Berk, sued in federal court under diversity jurisdiction for medical malpractice. So Delaware law, the law of the forum state, requires plaintiffs to file what's called an affidavit of merit if they wish to bring medical malpractice claims. Many states have these types of laws. Delaware law specifies that the affidavit must come from a qualified expert witness and attest that there are, quote, reasonable grounds to believe that the defendants committed medical malpractice. And the statute specifies that if somebody files a medical malpractice complaint that is not accompanied by one of these affidavits, the case has to be dismissed. So the question is whether this law applies in federal court when in diversity. So the plaintiff had filed this lawsuit initially pro se and had submitted his medical affidavits to the court, but not an affidavit of merit. And so after proceedings before the district court held that Delaware statute did apply in federal court, or was applicable even in federal diversity cases. And pursuant to that statute, since the plaintiff had not submitted the affidavit of merit, which the statute required, dismissed the case, and the Third Circuit affirmed that dismissal. The Third Circuit's analysis relied on 2 primary steps. First, the Third Circuit concluded that Delaware's affidavit of merit requirement did not conflict with any federal rules of civil procedure. And its analysis focused really on 4 main rules: Rules 8, 9, 11, and 12. Right, Rules 8 and 9 govern pleading standards in federal court. Right, Rule 8 is the general pleading standard. Right, Twombly, Iqbal, of course, explained what Rule 8 requires. Rule 9 provides heightened pleading standards for for allegations of certain sorts. Most notably fraud. And the court said neither Rule 8 nor Rule 9 had anything to do with the affidavit of merit requirement. These rules governed the contents of pleadings. The affidavit of merit requirement had nothing to do with pleadings. It didn't require, according to the Third Circuit, it didn't require that the plaintiff add certain details in the complaint. It didn't purport to impose any sort of heightened pleading standard on the complaint. Rather, it required the plaintiff at the outset of the case to provide particular evidence, to provide this affidavit of merit. And so Rules 8 and 9 were simply inapplicable to that issue. They did not purport to implicitly bar states from adopting such requirement or conflict with any such requirement. The court went on to observe Rule 11, right, obviously governs the conduct of lawyers, or it imposes restrictions to prevent lawyers from submitting frivolous filings. Again, the Third Circuit said because this rule governs lawyer conduct, it has nothing to do, or attorney conduct has nothing to do with whether complaints should be dismissed, has nothing to do with whether states can require plaintiffs to submit affidavits of merit. So it found no conflict with Rule 11. And of course, Rule 12 sets forth grounds for dismissal. The Third Circuit went on to say that nothing in Rule 12 purports to prevent federal courts from being able to apply state laws that require dismissal for various reasons, including failure to file an affidavit of merit. So because, in the Third Circuit's view, this issue was not governed by a rule of civil procedure, it went on to the second step of its analysis, which is to perform the Erie choice, right? So to determine whether under the Erie doctrine, state law governs this issue or federal law governs this issue, right? You might broadly remember, right, when federal courts are sitting in diversity, federal law governs procedural issues, state law governs substantive issues. And so in order to determine whether or not this was a substantive or a procedural requirement, the Third Circuit applied what it referred to as a modified outcome determinative test. It went on to say whether you apply this rule, whether you apply this requirement, could have a dramatic impact on the case's outcome, right? As in this case itself, a plaintiff if you apply this rule, a plaintiff who doesn't have the affidavit will see this case dismissed. Whereas if you don't apply this rule, a plaintiff who lacks the affidavit can nevertheless proceed, can nevertheless keep their case alive. And so precisely because applying this rule could have such a major impact on the outcome of a case, the Third Circuit said that under the Supreme Court standards, that weighed heavily in favor of it being deemed a substantive rule of law rather than just a procedural requirement, and therefore state law governed, and so the Delaware statute is applicable in this case. So the main issue before the Supreme Court is this Erie question, and my sense is that most of the focus of the case is really going to be on that first step of the analysis, that whether Rule 8 and in particular is construed very broadly as laying out requirements that once satisfied, once you have made a short and plain statement of your allegations, then you are entitled to proceed in federal court. If the Supreme Court gives Rule 8 that broad of an interpretation, then it would conflict with state laws that purport to require you to provide substantive evidence or to do something other than making a short and plain statement of your allegations. But on the other hand, if the court adopts a narrower interpretation of Rule 8 along the lines of what the Third Circuit did, if it doesn't find a conflict, it is very unlikely to do so, in my view, under any of the other rules. Rule 8 seems to be the most likely basis where the court would find a direct conflict. And so I think most of the case is going to hinge on whether Rule 8 guarantees plaintiffs who can overcome Twombly and Iqbal's pleading requirements entry into court, or instead states are allowed to add on additional requirements like the affidavit of merit as well. I'll conclude by pointing out that the Third Circuit position is definitely the minority position. At least based on the petition for certiorari, 6 circuits had held that affidavit of merit laws or their equivalents don't apply in federal diversity cases. Only 2 circuits, right, including the Third Circuit, had held that they do apply.
Great, thank you, Professor Morley. We do have a few questions. If you do have them, you can continue to type them, but I'm going to give you the first one. This person asked, the issue appears to be a matter of evidentiary submission similar to Rule 56 practice. So why is it not just procedural?
So the Supreme Court, or I should say the Third Circuit, let me step back for a minute. If there is a rule of civil procedure that is deemed to govern the issue, and as long as that rule is deemed valid under the Rules Enabling Act, and Hannah v. Plumer tells us that any rule that's even arguably procedural is valid, then the federal rules of civil procedure would govern the matter, and the statute would be thrown out of court. Only if there's not a conflict between the federal rule and the state law do you then actually get to a traditional Erie analysis where you apply the twin aims of Erie, and the terms substantive and procedural in that context actually mean something very different than they do when you're using the term substance and procedure under the Rules Enabling Act for purposes of determining whether the REA is valid. Whether a federal rule of civil procedure is valid under the REA. By the time you get to that Erie analysis, the court applies what it calls the twin aims of Erie. So it asks, will applying different laws in federal and state court facilitate forum shopping? Well, it gives plaintiffs an incentive to engage in forum shopping. If so, we're going to tend to regard those types of issues as substantive, where state law would govern. Would we think it's unfair to submit different litigants within the same state to different rules of law? Does this offend senses of justice depending on whether they happen to be in federal or state court? If so, that tends toward finding the rule at issue to be substantive. And so the answer to your question is, whether something is substantive or procedural differs dramatically depending on whether you're looking at the Hannah v. Plumer step 1 analysis or whether you're doing your unguided Erie choice at step 2.
Thank you. I have one other question for you. One listener mentions undue process and explains the injured has to work at being injured, ? Is that something that you feel, you can go right ahead and answer. I wasn't sure unless the person wants to type and clarify a bit, but.
Sure, it's not so much that they need to work at being injured under the state statute as they need to find an expert to say that the injury that they have suffered, that at least there's it's reasonable to believe that, or the exact language, or there are reasonable grounds to believe that the injury they suffered was the result of medical malpractice. So it's not so much that they need to work at being injured as they're, in order to get through the courthouse door, this state law requires you to have a qualified expert to say, yes, there's at least reasonable grounds to think medical malpractice occurred here, that they're trying to prevent, it's a tort reform statute. They're trying to prevent plaintiffs from jumping the gun and just assuming that their injuries, the harm that they're suffering is the result of medical malpractice.
Okay, thank you, Professor Morley. That concludes our questions for the presentation on that case, but we will return to you shortly. Our next presenter is Amanda Dixon. She is counsel at the Beckett Fund for Religious Liberty, and prior to coming to Beckett, she served as a law clerk to Honorable Allison Jones Rushing of the Fourth Circuit and Honorable James Dever III of the U.S. District Court for the Eastern District of North Carolina. And Amanda will be talking about Childs v. Salazar with us today. So without further ado, Amanda, you have the floor.
Thank you, and thank you for having me. For full disclosure, I was able to get to work on an amicus brief in this case on behalf of the Beckett Fund, and my colleagues at Beckett are preparing to argue a case raising a similar challenge to a similar Michigan law later this month at the Sixth Circuit. So Childs v. Salazar is getting argued on October 7th, and this case arises because Kaylee Childs, who's a licensed counselor in Colorado, and provides pure talk therapy, is a Christian who also, when her clients seek it out, provides faith-informed counseling. And many of her clients seek her out for that purpose. Her counseling, as I've said, is pure talk therapy, and it's also patient-directed. She follows the patient's set goals. And she contends that her counseling, some of the counseling that she would like to provide, is banned by Colorado's law banning conversion therapy for minors. Colorado defines conversion therapy, and this is kind of an important debate in the case of like the scope of what Colorado's law covers, but it defines conversion therapy as any practice or treatment by a licensed counselor that attempts to or purports to change an individual's sexual orientation or gender identity, including efforts to change behaviors or gender expression, or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex. Now, this has a couple of carve-outs. One is that it defines conversion therapy to not include acceptance, support, or understanding of certain practices such as coping and social support for identity exploration and development. And it also defines out of conversion therapy assistance to a person undergoing gender transition. So Mrs. Childs would like to provide counseling to minors who struggle with sexual orientation and gender identity and who seek to live in alignment with their faith, including becoming comfortable with their biological sex. She contends that the Colorado's law bans that practice on pain of fines or a loss of her license. Colorado has challenged this before the court, saying she doesn't have standing and that the counseling that she has said she would like to engage in is not covered by its law. So that's an active argument happening before the court, is exactly the scope of Colorado's law. But this is a free speech challenge to that law, and especially as it applies to Mrs. Childs' practice, which is purely talk therapy. She contends that this is a content and viewpoint-based regulation on speech. And as with many free speech cases, the key here is the level of scrutiny. The court below held that Colorado's law regulates professional conduct, not speech, and it subjected it only to rational basis review. Childs argues that it should be subject to heightened scrutiny. She situates her challenge in the line of a series of Supreme Court cases that reject the idea that there is a separate First Amendment category for professional speech that gets lower First Amendment scrutiny. And the most recent in this line of cases, this is a series of Supreme Court decisions that have upheld this idea that professional speech is not different. The most recent of those is NIFLA v. Becerra, where the court rejected the court below's contention that professional speech gets a lower level of scrutiny. Of course, here, the 10th Circuit didn't exactly say that professional speech was a separate category. It couldn't have under NIFLA, but it did hold that what Colorado has called treatment with words is not actually speech, that it is professional conduct in this context. So it'll be interesting to see where the court lands on this, if it continues in its line of cases rejecting attempts by lower courts to carve out speech in the professional context out of heightened First Amendment scrutiny. And of course, there are some categories of speech that the court has said gets lower scrutiny. Those are factual, non-controversial information in commercial speech and regulations of professional conduct that incidentally burden speech. So the court has also said, of course, there are some categories that don't get any scrutiny don't get any First Amendment scrutiny, things like incitement. The court has been very resistant to adding any new categories to that and has said that, it is possible that there could be other categories of speech, if proven by a long history of regulation that might not get heightened First Amendment scrutiny. Colorado tries to situate its ban within that. It argues two categories of historical regulation by states that it thinks that this should fall into and that it wouldn't implicate heightened scrutiny. Those are medical malpractice laws and informed consent. Of course, Childs does not agree that this law would fall within those historical categories. She argues that the ban is not similar to those analogs because it's a prophylactic ban and it's content and viewpoint based. Medical malpractice and informed consent usually don't involve those characteristics. So she argues that those aren't relevant analogs for the historical First Amendment exception analysis. Both parties have briefed intermediate and strict scrutiny. So in this case, if the court wants to reach either of those, if it determines that one applies, it could do so. The court also obviously could determine the level of scrutiny it thinks is applicable and remand to the lower courts to decide that in the first instance. And the last thing I'll add on that is just that the United States has filed an amicus brief in support of Childs, arguing that this is a content and viewpoint-based regulation on speech and that strict scrutiny should apply. The government urged the Supreme Court to remand for the 10th Circuit to apply strict scrutiny in the first instance, but also argued that if the court did decide to address strict scrutiny, that the law would fail. The Solicitor General's office asked for time at argument, and the court has granted that request. So we'll also be hearing from the United States at oral argument.
Excellent, thank you. Well, we have a first question for you is, and I don't know if you're able to answer this, but please feel free to do so if you can. Why is Childs not focusing on a free exercise claim? And instead is strictly a free speech claim?
Yeah, so I can't answer the strategic
question.
Yeah, I can't answer the strategic question. What I can say is that Childs does have a free exercise claim in the case. The 10th Circuit considered her free exercise claim, but the cert petition only included a free speech question presented. So that's the only thing that the court has granted here. So it's not before the Supreme Court, but there is a free exercise claim in the case. Okay,
wonderful. Thank you. And let's see. And I think that's it for now, but if there are any other questions at the end, we can, if they arise, people can feel free to ask them. We will go on. So thank you so much, Amanda, for that presentation. And we will go on to our next presenter. Give me one moment here. Okay, want to make sure I get everyone's details correct. So we have we have Professor Morley back first. He's going to be discussing Bost v. Illinois State Board of Elections. So Professor Morley, after a brief break, you are back with us again. So without further ado, please feel free to start.
Great, thank you very much. So the plaintiffs, so this is a case about Article 3 standing. So the plaintiffs in this case are incumbent Congressman Michael Bost, who was running for re-election at the time, as well as 2 Republican candidates for presidential elector from the state of Illinois in the 2024 election. So Illinois has a state law that specifies that election officials must accept absentee ballots as valid and count them so long as they are postmarked by Election Day, even if they receive them up to 2 weeks after Election Day. And if a ballot lacks a valid postmark, it can still be counted if the voter submits an affidavit swearing that it was that they had sent it out by Election Day. And again, election officials receive it within the 2 weeks afterwards. So the plaintiffs claim that this deadline allowing election officials to count ballots that they receive after Election Day conflicts with federal laws, at least as applied to federal elections. There's a long-standing provision in Title II of the U.S. Code that says that the Tuesday next after the first Monday in November in every even-numbered year is, quote, established as the day for election for congressional representatives. There's a comparable provision in Title III specifying the day on which states must appoint their presidential electors. And so the underlying merits issue of this case, which is actually not what the court's going to be resolving here, but the underlying merits issue is what these statutes mean, and in particular, what acts with regard to an election states must perform on Election Day itself for congressional elections or presidential elections, what steps in the electoral process may happen after Election Day. But the lower courts didn't get to the merits because they dismissed the case for lack of standing. And the standing analysis, of course, right, tracing back to Lujan versus Defenders of Wildlife, the very first thing a plaintiff has to establish is that they have suffered a concrete and particularized injury in fact that has either occurred or that is imminent, that is likely to be occurring soon. And the Seventh Circuit held that the plaintiffs had failed to satisfy that standard, that the plaintiffs had failed to demonstrate that Illinois' choice to accept these allegedly late ballots in alleged conflict with federal law would harm them, because with regard to Congressman Bost in particular, first it looked at his most recent election in 2022, and the court said that the number of what I will call late received ballots or allegedly late received absentee ballots hadn't been sufficient to impact the election's outcome, hadn't been sufficient to jeopardize his victory. And so therefore he had not been harmed by the state's past decision to accept those ballots and count them as valid. And with regard to the then impending 2024 election, they said it was purely speculative as to whether he would be impacted by the state's decision to count these late arrived ballots. So the court essentially held, even if it was illegal under federal law for election officials to accept ballots that come after Election Day, unless a candidate can show that those ballots in particular are reasonably likely to impact the election's outcome, the candidate doesn't have standing to bring a pre-election challenge. Of course, after the election is over, if it turns out that the margin of victory in that election is less than the number of late or allegedly late arrived ballots, then the candidate would have Article 3 standing. So the court's ruling in this case makes it much harder to bring pre-election challenges, particularly for candidates to bring pre-election challenges to the validity of the rules that election officials will use to conduct that election, and tends to shift those challenges, if they can ever be brought at all, to after the election. So the plaintiff's main argument in this case is that really twofold. On the one hand, in general, candidates do have a concrete, particularized injury in fact to having the elections in which they participate, the elections in which they are running, be conducted according to legally valid rules, regardless of whether they can show a sufficient likelihood of being prejudiced by potential violations of those rules. And then, but more specifically, Congressman Bost is arguing that there actually is a sufficient risk of him being harmed by the state's decision to allow these allegedly late received ballots, that he should be permitted to bring a pre-election challenge rather than having to wait until after the election. From a pragmatic perspective, the plaintiffs appear to have the stronger of the argument. Right? If candidates are forced to wait until after an election is held in order to challenge election officials' allegedly illegal conduct, that puts candidates in the position of having to challenge the apparent results of a completed election. And more importantly, it puts candidates in the position of having to ask courts to reject votes that had been apparently legally cast at the time. And in the worst case scenario, of course, asking courts to have to conduct an entirely new election. It's far burdensome to ensure that an election is properly conducted in the first place and that people have the opportunity to exercise their fundamental right to vote, rather than requiring candidates to wait until it's sufficiently likely that the alleged violations either will actually impact the election's outcome or have actually impacted the election's outcome. I will point out that the United States has filed an amicus brief in this case in support of Congressman Bost. It's filed a motion to participate in oral argument, and again, particularly in light of some of the court's other recent election cases dealing with issues such as laches and the issues that arise in trying to challenge votes that have been legally or were apparently legally cast at the time of the election itself. I think this is something where the petitioners, where Congressman Bost seems to have a very good likelihood of success, but we will see.
Great, thank you, Professor Morley. Very interesting. I'm opening up for questions. Do we have any questions for Professor Morley? Give it a few seconds. Okay, well, thank you, Professor Morley, for your time. That was very interesting. I've done some election laws. It's great, so thank you. Our next presenter is Matthew Cavadon. He is formerly he's the director of the Project on Criminal Justice at the Cato Institute. He formerly served as a Georgia public defender, as well as a fellow at the Institute for Justice. He also has taught law school courses on criminal law and procedure, as well as the First Amendment, and he clerked for U.S. District Court and the Supreme Court of Georgia. So the first case he's going to be discussing with us, he's going to be doing two. The first is Ellenberg versus U.S. So without further ado, Mr. Cavadon.
Thank you very much. Halsey Ellenberg had really unfortunate timing. He committed a bank robbery in the mid-1990s, and as of the day that he committed that bank robbery, federal law did require him to pay restitution back to the bank, but it set limits on that restitution. For one thing, there was a window of time after which Mr. Ellenberg would no longer have to pay restitution. I believe it was around 10 years. Secondly, interest did not accrue on the money that he owed. Mr. Ellenberg was then sentenced to around 20 or 25 years in prison. He did make regular payments toward restitution, but it was at prison wage speed, so it was a few dollars here and there. Mr. Ellenberg had bad timing because not long after he was convicted and headed to prison, Congress changed the law regarding criminal restitution. It kicked out the deadline for how long somebody has to pay restitution to calculate it based on when they get released from prison rather than the day that they're sentenced. In addition, it required courts to include interest payments in the amount that a defendant has to pay. So Mr. Ellenberg, after being released from prison, found himself not only with his debt still standing, but with it having actually increased to more than he had already paid, still outstanding, and to a much broader time horizon where he just has to keep on making these payments. There is a possible constitutional limit to how much Congress can change the law as it affects criminal punishments. The Constitution's ex post facto clause prevents the government generally from increasing the punishment for a crime after that crime is committed. So if Congress had increased the maximum sentence for prison time that Mr. Ellenberg faced, he would have been entitled to be sentenced only under the old provision. The question presented by this case is criminal restitution criminal punishment? Or is it some sort of civil remedy that's caught up in a criminal case, but that's not actually covered by the ex post facto clause, which applies only to criminal punishments? So that's the legal question, the constitutional question at the heart of this case. Cato filed a brief arguing that indeed criminal restitution is part of criminal punishment. There are a number of different reasons why we argue that that's the case. For one, it's imposed as part of a criminal sentence right there next to you. How long do you have to serve in prison? Who do you have to report to for probation? What sorts of things can you and can't you do? Is the line that says how much restitution you have to pay and for how long, so on and so forth. Secondly, it is not just that Congress rolled restitution into criminal cases to make things easier for civil plaintiffs. Rather, restitution is seen as part of the criminal sentence. It serves the same purposes as the sentence. It's meant in part to punish a defendant for wrong they have done. It is meant to dissuade other people from committing crimes. It's meant to deter the defendant from going out and offending again. And it's meant to be part of the rehabilitative process of taking accountability for one's actions and paying back a debt to society. So, for all those reasons, at least our brief argues that this isn't just a civil remedy that finds itself by accident within a criminal case. Rather, it's part of criminal punishment. And if it's part of criminal punishment, then it has to be covered by the ex post facto clause. There are a number of other cases that have addressed interesting pseudo punishment, debatable punishments within the context of the ex post facto clause. A really famous context where this comes up a lot is sex offender registration. A lot of the modern sex offender registration laws and restrictions on where sex offenders can live, where they can work, how they can interact with children, were passed within relatively recent memory, 1990s, early 2000s. So there were a large number of defendants who committed their crimes before that, but who then were suddenly hit with requirements to register, and they had never been subject to that before. The Supreme Court ultimately held that those kinds of restrictions are not, in fact, criminal punishments. They're civil measures meant to protect society. Even though somebody only becomes a legally recognized threat to society by virtue of having been convicted of a crime and having committed a crime, the Supreme Court still said that this is a class of people who can just be subject to civil safety measures. Even though the ex post facto clause would not allow those measures to be imposed as criminal punishment, they were still valid because they were not technically criminal punishment in the way that the Supreme Court treats it. So that's going to be the question is criminal restitution analogous to sex offender registration requirements, where it's a civil safety measure taken after the fact? Or is it, as again we argued, is it part of the criminal punishment system as a whole and should be treated as covered by the ex post facto clause? Our brief actually argues that the Supreme Court should revisit some of the other things that it has not considered to be criminal punishment. Sex offender registration requirements would be one area to look. Another is civil asset forfeiture. Civil asset forfeiture by the Supreme Court has been considered to be sideways to criminal proceedings. And so if a legislature passes a law authorizing the seizure of certain property, presumably that would not be covered by the ex post facto clause either, because it's a civil measure. We think that that's too wooden of a distinction, that really it comes down to, is this something that only happens to you because you've been proven to have committed a crime? Is this the sort of thing that's aimed at achieving the same goals as incarceration and other traditional criminal punishments? Is this the sort of thing that quacks, walks, eats breadcrumbs just like a duck, and therefore should be treated as a duck for purposes of the ex post facto clause? So we'll see if the Supreme Court agrees.
Great, thank you so much. Do we have any questions at this time? No? Okay, so I'm actually going to have you continue to present if you're okay. For the next one, you will be presenting Case v. Montana. And so feel free to go ahead.
Certainly, Case v. Montana is another Fourth Amendment case. I say another because it seems like every few terms or so, there's a pretty standard policing issue that comes up within the context of the Fourth Amendment. And this is another example of that. Case v. Montana builds off of the court's decision just a term or two ago in Cornelia v. Strom. So, for a long time, the Supreme Court noted that there are contexts where police are responding to properties without necessarily investigating criminal activity. In Cornelia v. Strom, the state of Rhode Island said there's in fact a Fourth Amendment exception for what's called community caretaking. When police officers are not going out to a house in response to alleged criminal activity, they're not out there investigating a crime, but they're out there for the purposes of some other concern around public safety. In Cornelia, there was a dispute between a man and his wife. There was concerns about possible self-harm or mental illness. So the police responded and went in to retrieve Mr. Cornelia's firearm. The Supreme Court in that case said that there is no free-floating community caretaking exception to the Fourth Amendment. That police officers, whenever they're entering the castle that is somebody's home, they generally are covered by the Fourth Amendment's requirements to either have a warrant or have some other discrete, historically recognized exception for going and getting a warrant. So in Cornelia, the court said there is no community caretaking exception to the warrant requirement. The only similar exception is what's called exigent circumstances. Whenever police face an emergency situation, they may be able to enter into somebody's home without a warrant. If a police officer is walking the beat in a neighborhood and hears screaming from somebody inside saying, "Help, help, I'm being attacked," no, the police officer does not have to stop, get out their cell phone, call up the on-duty magistrate judge, get a warrant, and then go in. In fact, nobody wants them to do that. When a police officer hears an emergency going on, we expect an officer to go ahead and proceed in. That is constitutionally reasonable, even though there's not a warrant under those circumstances. What if you don't hear somebody screaming and they're in active danger, but police have other concerns? That's the question raised by Case v. Montana. Mr. Case's ex-girlfriend called the police and said he is threatening to commit suicide. The police arrived on scene at the house, but did not immediately make entry. They looked through the windows, they looked for signs of disorder. They didn't see a ton. They saw a gun holster on the table that was empty, but that was it. They didn't see any other signs of disruption or causes for concern. Not to say that they weren't concerned, but they did not immediately make entry into the house. In fact, part of the reason that they didn't do so was because, based on previous calls out to the house, police believed that Mr. Case may have been attempting what's called blue suicide, which is where somebody who is suicidal has the police kill them in a standoff rather than killing themselves. The police were unsure what to do. They, in fact, spent about 45 minutes deliberating. None of the officers during that time called and sought a warrant to enter the home. Instead, after 45 minutes, they decided that they were going to go ahead and make entry based on exigencies. They entered the home. They did find Mr. Case hiding in a closet. Nearby, they found an illegally owned firearm in a laundry basket. They seized the gun. They're now prosecuting Mr. Case for the gun possession charge based on that firearm. He moved to suppress the firearm and said that the entry into the home was unconstitutional. Montana made a very particular choice in litigating this, and I'm not sure what the particular reason for that was. Montana conceded that the officers did not have probable cause to enter the house. They argued that all that the officers needed and all that the officers had was reasonable suspicion, which is a lesser showing. But they said, when you have reasonable suspicion of exigent circumstances or of an emergency, that's all that you need to enter into a home. Reasonable suspicion is not one of the super ancient doctrines in criminal procedure. It was created by the Supreme Court in Terry v. Ohio in order to justify stops that fall short of a full-blown arrest. But it doesn't have a whole lot of originalist pedigree as a way of thinking about the Fourth Amendment. The question that the court is going to have to face now is that sort of in-between, I don't mean made up too dismissively, but made up category. Is that enough to justify an entry into the home? The Supreme Court has said on numerous occasions entry into the home is at the heart of the Fourth Amendment's concerns. The warrant requirement is meant to protect certainly Americans' privacy within their own homes and the liberty that comes with that, but also to protect human life. Home entries are particularly dangerous. They're dangerous for people who are suspects. They're dangerous for homeowners, especially if officers show up at the wrong home, as happens sometimes. They're dangerous for officers who may be fired upon when they enter into a home. For all of those reasons, the court has said we expect a pretty high quantum of proof before officers enter into a home, as they did in the case. Don't let that be too confusing. In Mr. Case's case, the question is probable cause still required or a warrant required under this exigent circumstances exception? The case itself is going to regulate police behavior nationwide, so it could have a significant effect. There's not necessarily a ton of room between reasonable suspicion versus probable cause. Different judges are going to make different judgment calls as far as what side of the line that falls on. Nevertheless, Cato did file a brief in that case as well, discussing some of those traditional Fourth Amendment requirements and the importance of having strong evidence before making a home entry, especially in light of the fact that, again, the officers here claimed to be facing an immediate emergency that stopped them from getting a warrant, but also chose to wait 45 minutes before actually entering into the home.
Thank you, Matthew. I think we will go on to our last presenter, Mr. Richard Riley. He is a partner at Baker Hossetter, where he does appellate law as well as with a focus on election law. He has represented parties and amici at every level of the judiciary, trial courts, merit litigation, and the U.S. Supreme Court, as well as state Supreme Courts. He has litigation experience involving a variety of different matters: commercial litigation, civil rights, constitutional, campaign finance, voting rights, labor, and bankruptcy laws. Today, he will be presenting for us Louisiana v. Calais, and I will hand the mic over to Richard.
Thank you, Ariel. This case comes out of Louisiana's congressional redistricting. The state of Louisiana was told by the Fifth Circuit, as well as the federal district court, that its congressional map likely required a second majority Black district. That case is called Robinson. As a matter of full disclosure, I was a lawyer for the state legislative leaders in Robinson. I am not involved in the Calais litigation. The theory that was utilized in the Robinson case is under Section 2 of the Voting Rights Act that was interpreted in a case called Jingles, which I will refer to as Jingles, and describes the conditions under which a state becomes obligated to draw a majority-minority district. As I said, the Fifth Circuit said in preliminary injunction proceedings that the state of Louisiana likely was obligated under Jingles to draw a second majority Black district. Rather than continue to fight that case, the legislature elected to redraw the map itself. And in fact, the Fifth Circuit had explicitly invited the state to do so and urged it to do so. The state drew a second map with a majority Black district, but it had a different political impact than the illustrative district that had been presented by the plaintiffs in Robinson. The illustrative district in Robinson would have impaired the electoral prospects of Julia Letlow, who sits on the Appropriations Committee, a very powerful member of Congress. It may have harmed the electoral prospects of Speaker Johnson. So the legislature, as you might imagine, is very concerned about a situation in which a federal court draws the congressional districts of Louisiana and harms electoral prospects and the standing of the delegation in Louisiana. So it enacts that plan. A second challenge called Calais, which is our case, followed quite quickly as voters in the new district challenged that district as a racial gerrymander under a theory that I will refer to as Shaw. A constitutional case against a congressional redistricting plan is subject to the 3-judge panel act and goes to a 3-judge district court. And so it couldn't go to the same judge who decided Robinson. It was a single judge that can preside over a Section 2 Voting Rights Act claim. So you have new judges. Additionally, that case from a 3-judge district court is immediately appealable to the U.S. Supreme Court and is on its mandatory docket. The new judges look at the new majority black district and apply the Shaw theory, which asks first whether race was the predominant factor in the creation of a district, and second, if so, whether the state can prove that the use of race was narrowly tailored to a compelling state interest. And the Calais court determined in a split vote that yes, race predominated, notwithstanding the political goal that I just described, and that notwithstanding the Fifth Circuit ruling, the district was not narrowly tailored to a compelling state interest. The state appealed, the Robinson plaintiffs intervened, and they appealed as well. I think it's important at the outset to understand the case in context, and it's helpful to contrast it with the current state of affairs in Alabama. That state was also told in litigation during preliminary injunction proceedings by a district court and the U.S. Supreme Court that it too likely needed a second majority black district. It too elected to redraw its map after the preliminary injunction proceedings, but Alabama did not draw a second majority black district. The federal court in that case determined that Alabama not only violated Section 2 of the Voting Rights Act, but that it also violated the U.S. Constitution. In short, we have two states very near each other who have made different choices with respect to preliminary injunction rulings directing second majority black districts, and both were found to have violated the U.S. Constitution. Hopefully, you all can get the sense that something isn't working very well in this area of law. And it comes down to a conflict with the Shaw theory and the Jingles theory. The Supreme Court considered Calais last term and had fulsome briefing under the doctrine as it exists presently, and it was not able to resolve the case. It has ordered re-argument in the case to answer a more fundamental question of whether the state's intentional creation of a second majority minority district violates the 14th Amendment. A little background may help to understand how we got here. Jingles, as I said, describes the circumstances where a majority minority district is required. A plaintiff has to show a reasonably compact minority population, racial bloc voting, and then show that under the totality of circumstances, the voting opportunity is not equal. When that case was handed down, the practical effect in redistricting across the nation by legislators controlled by both parties was to find minority population, draw a circle around them, call it a district, obviously make sure it's equally populated, and then fill out the remainder of the map. That was very common because that's the easiest way to avoid Section 2 litigation. Shaw arose in the 1990s, and it was not originally conceived as a challenge to that framework, or at least it was not originally framed that way. Shaw was controversial from the beginning. It was developed in a series of 5-4 rulings where the decisive vote was Justice O'Connor. In those cases, Justice O'Connor described the doctrine as an extreme case doctrine. She used the word extreme instances because in that decade, legislators, and they were typically Democratic legislators, drew very bizarre districts, including freeway districts, districts described as being in the shape of a Mayan bird, a district that joined Atlanta and Savannah, into these weird districts that were actually being urged by the U.S. Department of Justice. And the Justice O'Connor found these districts to be problematic, as did the sort of conservative side of the court. The so-called liberal side of the court was in dissent, including Justices Ginsburg, Breyer, Souter, Stevens, and Justice White for the first case. And the dissent made the argument that in an equal protection racial discrimination claim, where there's not a racial classification that appears on the face of a statute or a rule, there's a requirement of both discriminatory purpose and discriminatory effect, some kind of harm. And they made the point that when you are in District 1 versus District 2, without any showing that it dilutes your vote or it harms your electoral prospects, which Shaw excused, there's not a harm. There's an intent that's racial, but there's not a harm. That position lost, but there was a limiting principle that appeared in the writings of Justice O'Connor that although it didn't require a discriminatory effect in the form of vote dilution, only districts that were shown to substantially derogate from traditional districting principles would be subject to strict scrutiny. Accordingly, according to Justice O'Connor, the swing vote, the majority minority districts of this country were not at issue in Shaw. It didn't concern that. At the time, Justice Scalia took a much broader view and took the position that any time a state draws a district to hit a racial target, which is what a majority minority rule is, it's a racial quota, it should be subject to strict scrutiny. And the state should have to effectively prove a Voting Rights Act claim against itself. For a time, this doctrine did not, other than the districts struck down, which includes, by the way, districts in Louisiana. There was Hayes litigation in Louisiana where districts, one was in the shape of a Z and one slashed across the state, not actually that different from the new district in some ways, were struck down as racial gerrymanders. They failed under this theory. But the next decade, it was much quieter because there was an understanding to draw the majority minority districts in the same way that other districts were drawn, and there wouldn't be a strict scrutiny problem. That changed last decade, and for an arguably unlikely reason, which was that voting rights groups associated with the Democratic Party, all of a sudden saw in Shaw a possibility to gain some seats across the South, which was now being redrawn by Republican-controlled legislators. And they came into court with a very muscular view of Shaw that was not that different from what Justice Scalia had proposed, that the states had adopted a quota, 50%, sometimes 55%, and that this should subject the district to strict scrutiny, which they couldn't survive under this theory because there was no statistical analysis demonstrating legally significant racial bloc voting. This was largely successful. More than 50 districts in the United States were struck down as racial gerrymanders last decade. All but one of them, at least that I'm aware of, was drawn by a Republican legislature and challenged by Mark Elias, NAACP, Legislative Black Caucus, a group along those lines. And the theory that developed was actually caused because the left side of the court threw its full weight behind Shaw. Justice Kagan wrote the leading opinion, Cooper versus Harris. Justice Ginsburg, Justice Breyer, Justice Sotomayor all came over and started voting for a very muscular version of Shaw that came close, not entirely, around to saying that the mere goal of a majority minority target triggers strict scrutiny. And in a case called Bethune-Hill, which I participated in, the court explicitly rejected the O'Connor framework and said there's no requirement of conflict with traditional districting principles. So that begs an interesting question. As Shaw increases, shouldn't jingles decrease? Which was the implication that was being leveled against the claim in the 90s that this was designed as a backdoor attack on the Voting Rights Act. As of the 2000 cycle, people aren't saying that so much anymore, but it does beg the question, how can states, one, draw these districts, and two, how can courts compel them to draw these districts with this highly muscularized version of Shaw? that becomes the question this decade. And in a case out of Alabama called Milligan, the court was presented with its first opportunity to ask whether Shaw would change jingles. And the answer the court gave was no, except maybe. The court was highly divided. Justice Roberts cast the deciding vote to uphold jingles. And this is the case where Alabama is told it needs a second majority Black district. But the decisive vote is cast by Kavanaugh. In his concurrence, he says that Section 2 doesn't have an expiration date. And typically, as we know from the Students for Fair Admission or SFFA litigation, racial classifications need to have an end date. And Kavanaugh said maybe that's a problem here. He's the decisive vote. Moreover, there's a section of Milligan, 3B1, that cites Shaw and may read some of Shaw into jingles to limit it, except that Kavanaugh, for some reason, didn't join 3B1, so it was a plurality. And it's hard to understand what it's saying anyway. So we have maybe jingles gets curtailed, maybe not. Hence, Calais. Here, the state appealed, the Robinson plaintiffs appealed, and the state defended the district. And the court had what it needed to resolve the case under existing doctrine last term. There were basically two views of the case. One, you could view the district, which did slash across the state, starting in Baton Rouge and going to the northwest, a little bit like some of the Hayes district. You could view them as not sufficiently compact to be narrowly tailored under the Voting Rights Act, not enough like the remedial district in Robinson to pass muster. And thus, the district should be invalidated, which was what the district court said. Or the court could view it as a matter of legislative discretion. Once the violation is found, there is lots of case law that says the legislature should be able to choose the political impact. Here, the legislature didn't want to compromise its standing in Congress with the congressional delegation for very good reason. So there's a very good theory by which it might be upheld. It appears that the court can't agree on either of those frameworks or on any of the other arguments that were made in the case, and there are others. And so it is asked for a much broader, more fundamental question, and it references pages 36 to 38 of the brief for the appellees. That's interesting because Justice Kavanaugh at oral argument also cited pages 36 through 38 of the brief for the appellees and tied it to his concurrence in Milligan, where he said, as I said, that maybe Section 2 needs an expiration date. So all of a sudden, this becomes maybe an SFFA type challenge to the Voting Rights Act itself or to the very idea of challenging majority Black districts. Seems awfully coincidental that Justice Kavanaugh is having these doubts and we have these pages referenced. So the state has switched sides and is now arguing that it violated the Constitution by adopting this district, and the court should effectively return it to where it would rather be. And to its credit, it had always said we would rather have one than two majority Black districts. We didn't agree with the Robinson ruling, they said, but they felt obligated to follow it. So the only parties now defending the map are the Robinson plaintiffs, who are obviously defending Congress's power to enforce the 15th Amendment, emphasizing that Section 2 requires evidence based on current circumstances. And so that's the built-in timing concern that should address Justice Kavanaugh's concern. And there are innumerable amicus briefs. The Solicitor General has filed a brief suggesting that jingles be reworked to incorporate lots of the concepts of the Shaw doctrine in such a way that the Robinson plaintiffs would never, I don't think, be able to meet that standard, and the case would return to one majority Black district. The case will be argued on October 15th.
Thank you very much. That was excellent. I have a question for you. How can or how does any of this apply to the current mid-decade redistricting battles between the major political parties among several of the states?
Could you repeat that? I didn't
Yeah, of
quite catch
course,
that. Yes.
absolutely. How can or how does any of this apply to the current mid-decade redistricting battles between the major political parties among several of the states?
It applies not directly. I think it applies more indirectly, and it certainly applies politically. Let me say a few things about that litigation. A lot of the Republican legislatures after last decade, and they saw lots of districts struck down, as I described, took an approach of not considering race at all and taking their chances under Section 2. And there are means by which plaintiffs will try to make a case that even though they deny the use of race, the legislature actually used it secretly. There's a case called Alexander out of South Carolina that makes that very, very difficult, but it's being tried anyway. There's no constitutional problem with mid-decade redistricting. The court held that in a case called Lulac versus Perry. So the plaintiffs in these cases don't have an argument, or at least not a good argument, that there's some kind of problem with mid-decade redistricting. What is being argued in some of these cases is that race was used and that either a Shaw doctrine or actually an intentional vote dilution doctrine, which is analytically distinct, has been violated. So it may be relevant there. Some of the politics may be relevant. I don't know what's sort of going on inside the state of Louisiana. My representation there has ended. But we know that the White House is asking for more Republican districts. If Calais goes as the state hopes, that will be probably will be another Republican leaning district. So there's sort of political motivations all the way around. You cannot separate either the litigation itself, the line drawing process, or anything about the decisions from politics. So there are shades of overlap, but legally the issues probably will be distinct.
Excellent. I have one more question for you, and then I will wrap up with the summaries of the 3 cases that were not covered. How may this decision, if at all, affect the validity of the pending Proposition 50 in California, which would restructure all the districts to eliminate 5 Republican congressional seats?
The case would affect it if the resulting map were shown to be impacted by race. There's nothing about the proposition itself, the ballot process, potentially ending or I guess putting a hiatus on the California Independent Redistricting Commission that concerns the U.S. Supreme Court, at least presently. The commissions were dealt with in a case out of Arizona last decade. So if the resulting map was impacted by racial considerations by the legislature or whoever drew the map, then it may well be vulnerable under the theory that's at issue here. If not, not.
Okay. Last question, and then I will let you go. Is it possible that the Supreme Court could simply rule that any motivation based on race violates the 14th Amendment under strict scrutiny, notwithstanding anything to the contrary in the Voting Rights Act?
Yes.
Okay.
That is possible. It's I read some of the briefing of the parties to ask for that. The Solicitor General has urged that the predominant standard remain. I have, as a practitioner, I don't view the predominant standard to be that robust. And in fact, as I kind of suggested, there are arguments to be had that the predominant standard may actually be easier to meet than standards in other areas of equal protection litigation. I don't know that that's something that members of the court have necessarily thought about, but it's not that hard to show racial predominance when there is a goal of complying with the Voting Rights Act. The state had argued, for example, that politics predominated. Race didn't predominate, politics predominated. And I think Justice O'Connor would have endorsed that. I think they would have won under her worldview. for the reasons I said. But today, they really didn't have a very good shot on that because the standard is so low. It's so easy to prove predominance where you have a majority minority goal that they really didn't have a chance of winning on that. And they clearly have not persuaded the Supreme Court that the district is race neutral, or else the new question presented wouldn't be phrased the way that it is.
Excellent. Thank you. Well, thank you so much, Richard. We greatly appreciate that. And that concludes the presenters. I'm going to go over the 3 last cases that we did not have presenters for. It'll be very speedy, but hopefully give you a quick overview of the question that the Supreme Court will be hopefully answering. The first one I'll be discussing is U.S. Postal Service v. Conan. This is actually sort of an interesting fact pattern. It's something you might see in law school, but it feels a bit silly, but it's not. There was an instance in which U.S. postal workers were actually intentionally not delivering mail to an individual to one of her properties. They actually changed the locks on one of her mailboxes. Even after ownership was confirmed on her property, the 2 postal workers continued to halt delivery. Conan, the woman who owns the properties, she's a Black woman, and she believes that this may have been done due to racial discrimination. That's what she alleged. So she sued U.S. Postal Service, the 2 postal workers at issue, the United States as well under the Federal Tort Claims Act. She alleged violations of equal protection guarantees under both 1981 and 1985. The district court dismissed her FTCA claims for lack of subject matter jurisdiction. There is a postal matter exception, which basically is under 28 U.S.C. 2680B. The government retains sovereign immunity for, quote, any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. So the question here was, did the behavior of the postal officers, it seems very flagrant in my mind, but the behavior of the post officers here who intentionally refused to deliver her mail, did that actually fall under this postal matter exception? And so going back to the procedural history, the district court dismissed her FTCA claim, saying that, yes, it fell under this exception, and that her equal protection claims were failed for failure to state a claim. The Fifth Circuit affirmed the dismissal of the equal protection claims, but actually reversed on the FTCA claim, holding that sovereign immunity did not preclude her from bringing claims based on intentional acts of mail non-delivery. And so the question that the court will be answering is, does a claim that the Postal Service employees intentionally refuse to deliver mail to a designated address arise out of, quote, the loss or miscarriage of postal matter under the FTCA's postal matter exception? So it's kind of an interesting, quirky case. The next 2 are both Hobbs Act robbery cases, which I'm sure you're gonna, I'm sure the clerks love those ones. The first one is, it's Hobbs Act robbery, but it's actually a habeas case, and it concerns the interpretation of AEDPA. EDPA cases or habeas cases are always really long procedural histories, but I have tried to shorten it to the best of my ability to get to the nugget that will be of interest to us. So in 2008, Michael Bowe was charged with conspiracy to commit Hobbs Act robbery, attempted Hobbs Act robbery, and using a firearm during a crime of violence. He pleaded guilty in 2009. He received a 288-month sentence, which included a mandatory consecutive 120-month term for the firearm conviction under 924C. Starting in 2016, he made multiple attempts to challenge his conviction through a series of motions and applications, arguing that changes in Supreme Court precedent meant that his underlying crimes no longer qualified as crimes of violence. The district court initially denied his first 2255 motion, finding that the attempted Hobbs Act robbery still qualified as a crime of violence. After that, he filed applications seeking to file additional challenges, and he was denied several times by the 11th Circuit, which ultimately concluded that it lacked jurisdiction to consider his latest application because he was attempting to raise the same claim he'd already presented in previous applications. And EDPA requires the dismissal of second or successive motions to vacate under Section 2255. So basically, the 11th Circuit continued to deny his application to challenge his designation as a crime of violence, Hobbs Act robbery. And so this is an interesting case because the Supreme Court is actually going to answer whether the rule requiring dismissal of repeat claims in state prisoner habeas petitions also applies to repeat claims in federal prisoner motions to vacate their sentences. And then the second is whether the Supreme Court even has the jurisdiction to review the grant or denial of authorization by a court of appeals to file a second or successive motion to vacate under 2255. So does the Supreme Court in this case, I guess as a threshold matter, even have the ability to evaluate the grant or a denial of an application to challenge challenge your conviction? So that is Bowe v. U.S. And I will do the last one very quickly in the last 3 minutes. This is another Hobbs Act robbery case, but this I will try to keep it as brief as possible. So this is Barrett v. U.S. Barrett was involved in several robberies one day, and he actually, one of the victims of his robbery ended up being murdered as he was trying to thwart the robbery. Barrett was indicted on multiple counts, including conspiracy to commit Hobbs Act robbery, 2 substantive counts of Hobbs Act robbery, and a separate firearms offense, which included a murder charge under 18 U.S.C. 924J. So he was convicted in 2014. He was sentenced to 90 years in prison. On appeal, the Second Circuit vacated one of the firearms convictions under the Supreme Court's decision in U.S. v. Davis. So then he was resentenced to 50 years in 2021. And after further appellate proceedings, the Second Circuit affirmed most of his convictions and sentence, but vacated and remanded for resentencing in light of the Supreme Court's decision in Laura v. United States, which held that 924J does not require consecutive sentencing under 924C. So what does all of that mean? I can go through basically the statutes at issue here. 924C, it's a very popular firearm statute. It prohibits possessing, carrying, or using a firearm to advance either a federal crime or violence or a drug trafficking offense. 924J is a part of the statute that captures aggravating factors associated with the crime in 924C. So under 924J, that applies when a defendant, in addition to violating 924C, has also, quote, caused the death of a person through the use of a firearm. So basically, if a murder occurs in conjunction with a 924C crime, that's when 924J will apply. Section 924J requires proof of the 924C offense, which I just stated, along with the death of the person. So the question at issue in the Barrett case is whether 924J, so that aggravating factor statute, effectively creates a separate crime that carries a separate punishment from 924C. And if that's the case, if they're 2 separate punishments, does that actually violate the Fifth Amendment's ban on double jeopardy, prohibiting sentencing a defendant for 2 different crimes because it's based on the same robbery? So that is the summary of the last 3 cases that we had. And I know that we have 1 minute left, so I think I will conclude there. But thank you, everyone, for sitting in. And thank you to our presenters. It was excellent. It was thorough. And we managed to stay right on time.
Perfectly done. To our entire panel, I want to say thanks for your efforts and expertise this afternoon. For our audience, your feedback is always appreciated at info@fed-soc.org. Until next time, thanks everyone for joining us. We are adjourned.
Thank you.